Please rise.
I can't.
Please be seated. This is People versus Pablo Forenza, 23T125. Mr. Forenza appears in custody. Mr. McCall is here for the people. Give me 1 second. I'm joining WebEx. I'm trying to. Mr. Forenza refused to stand before the entry.
I can't stand. I'm shackled like a criminal over a traffic citation.
Today's case is the perfect example of what happens when internet legal theories collide headfirst with courtroom reality. It starts with a simple traffic case, something that, in most circumstances, could be resolved with a fine, a brief hearing, and everyone moving on with their lives. But instead of taking that route, our defendant chose a completely different strategy. He showed up for his jury trial, refused to participate, declared that the court had no jurisdiction over him, and then walked right out of the courtroom. Now, if you've watched enough courtroom videos, you already know that judges tend to take a dim view of people abandoning their own trials. And while walking out may have felt like a dramatic act of defiance in the moment, there was one small problem. The court wasn't finished with him. A bench warrant collapsed. Jurors wasted their time showing up. Witnesses were left hanging. And the legal consequences kept quietly waiting in the background. Fast forward a couple of months, and reality finally catches up. The man who believed he could simply reject the court's authority now finds himself back in front of the same judge, this time in custody, in handcuffs, and facing a contempt hearing that could land him in jail. As you watch this unfold, pay close attention to the contrast between how the defendant views the situation and how the court left hanging, and the legal consequences kept quietly waiting in the background. The other side sees a defendant who deliberately ignored court orders and disrupted the judicial process. By the end of this hearing, one of those interpretations is going to win, and the result may not be what our defendant expected. Let's get into it.
No, you're not here on a traffic citation. You're here on contempt. Are
we having a contempt hearing, Your Honor?
Well, I'm going to give you that opportunity. I'm going to advise you if you'd like it. Let me start by reading the relevant portions of the contempt rule, Mr. Forenza. This is Rule 407. This is of the rules of civil procedure, but that same rule applies to criminal actions such as this one. I'll read the relevant sections. Subsection A1, disorderly or disruptive behavior, a breach of the peace, boisterous conduct, or violent disturbance toward the court, or conduct that unreasonably interrupts the due course of judicial proceedings, behavior that obstructs the administration of justice, disobedience or resistance by any person to or interference with any lawful writ, process, or order of the court, or any other act or omission designated as contempt by the statutes of these rules. This will be direct contempt, and I will cover that in a second, but the rule is direct contempt is contempt that the court has seen or heard and is so extreme that no warning is necessary, or that has been repeated despite the court's warning to desist. Subsection 4 defines punitive sanctions for contempt, which includes punishment by an unconditional fine, fixed sentence of imprisonment, or both, for a conduct that is found to be offensive to the authority and dignity of the court. Most notably is subsection B, as in boy, which says addresses direct contempt proceedings. When a direct contempt is committed, it may be punished summarily. In such case, an order shall be made on the record in writing reciting the facts constituting that contempt, including a description of the person's conduct, a finding that the conduct was so extreme as that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement in mitigation. Mr. Forenza, I'm going to offer you that opportunity in a little bit. I make a specific finding that all conduct that I'm referencing occurred in my presence and therefore is direct contempt. Very specifically, let me make some reference. Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He has filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court. but I was willing to let all of that go so we could try the matter. On the day of trial, which I believe was November 24th, Mr. Frenza appeared on time, but stayed in the gallery along with who I believe is his wife. I repeatedly, at least 3 times, but perhaps 4 or 5, told him to approach the court, to cross the bar and sit at table so we could address the trial. Mr. Forenza failed to do so in my direct presence. He told me I had no jurisdiction, left the courtroom, and then amazingly was able to leave the building as well.
Right out of the gate, the judge cuts through the defendant's framing of the situation. Notice how Pablo immediately tries to characterize himself as someone being treated unfairly over a simple traffic citation. It's a powerful rhetorical move because it shifts attention away from what actually brought him here today. The judge isn't interested in revisiting the original traffic matter at this moment. Instead, he's focused on the conduct that occurred inside the courtroom itself. That's a critical distinction. Courts generally have a lot more moment. Instead, he's focused on the conduct that occurred inside the courtroom itself. That's a critical aren't about speeding. They're about the alleged contempt, and that misunderstanding or refusal to acknowledge the difference becomes a recurring theme throughout this hearing.
In any event, he has not returned since November 24th, other than a few pleadings that I'm guessing were filed that day or the day before. I've had no interaction with this case since November 24th. I make a finding that Mr. Forenza was under an order to perform, that is to come to the table. He refused to perform in accordance with that order, and even though he had the ability to perform, obviously he was mobile, he was able to make it into the courtroom and then, of course, make it out. He was repeatedly warned, and I note that. I gave him multiple opportunities to approach, and he disregarded all of them. I make a specific finding that I find Mr. Forenza's conduct to be offensive to the authority and dignity of the court. I make a specific finding that he engaged in misbehavior that rises to the level of obstruction of justice. The behavior happened in my presence. The conduct was intentional and willful, and these actions seriously affronted and disrupted the administration of justice. In that regard, I will note that I went and met with the 30 or so jurors who had appeared for the trial, that Mr. Forenza simply blew off. I had to explain why that happened, and I had to waste all of their time. I also wasted the time of the witnesses. Mr. Forenza, I didn't waste anybody. Mr. Forenza also wasted the time not only of the jurors, but of the witnesses, counsel, the court, and everyone else. The court finds him in direct contempt. I made a similar record on the morning of trial, but Mr. Forenza had bolted from the courtroom, and therefore I find he was not advised at that time, so at least not in any significant way, and I hereby advise him. I am considering a jail term for the contempt unrelated to the underlying charges, Mr. Forenza. I'm going to offer you some opportunities of how you want to proceed. First, if you wish, you can make the statement of mitigation right now, if you wish to. If you do not wish to, if you wish to consult with counsel, I will give you time to hire your own counsel, but you will remain in custody during the interim. I would even be open to the appointment of counsel if you believe you are indigent. In fact, I would appoint counsel if you were indigent. How would you like to proceed? And if you'd like a few moments to think about that, I'm fine with that.
Is that the only option, is how I like to proceed, or can I make a statement?
Right, so I'm offering you option one and options 2 and 2A. 2A and 2B. Option 1 is you can make your statement of mitigation right now, right? And without counsel, the only person in the room other than court staff and the deputy is Mr. McCall. We are live streaming. You can make that. If you'd prefer, you can contact an attorney, and I will set this over for a time where you can make the argument through an attorney. Or appoint, that's 2A. And then 2B, if you believe you're indigent, I will appoint counsel.
Could you explain indigent, please?